I'm Jackie Atchison, I'm the Executive Director of the Arts Council for Monterey County, and I want to thank you all for being here on this beautiful Friday morning. It is going to be a rainy weekend, so be careful out there. Today's workshop, as you know, is going to be focusing on new laws affecting our nonprofits. And our speaker is Bradley Levang of Benton Keller, and his practice focuses on employment law, counseling, and litigation. He counsels employers on wage and hour policies and practices, employee misclassification issues, employment policies, leave issues, and compensation matters such as commission agreements and incentive programs. He also advises and represents employers regarding employment matters, including wage and hour class actions, discrimination, retaliation, and harassment litigation.
Wow.
So we're going to present on several topics today, mostly California law. But we might have a question or two about a federal law that's kind of disturbing for nonprofits. So, if you will, please join me in welcoming Brad.
I get my inaugural sip of coffee here.
And remember, please feel free to get up and get coffee, juice, and the restrooms behind that door.
Yeah, exactly. Feel free to move about. Feel free to cut me off if you have questions. You know, we're going to go about an hour today, but I don't mind if we go over if you don't. So, and not a problem with me. So, let's get started. So, today's topic: staying compliant in 2025. Key law changes for art nonprofits. So, the best way to start off with a new law seminar is to go back to the old laws. So, as you know, as many of you probably know, every year the California legislature is a resolution just making the world aware of California nonprofits. So June 5th, 2024 was the last time they did that, but this year they haven't yet. But it just recognizes the importance of California's nonprofits. I had not really read it much prior to preparing for this presentation, but then once I did, I was blown away by the details provided. For the uninitiated, California nonprofits are a very large segment of California. I was amazed by that. So they contribute about 15% of California's gross state product. They are the fourth largest employer by industry in the state. So if you think about all the industries that are in California, that's pretty impressive. Over 1.2 million people are employed by nonprofits. The volunteers that help nonprofits are the equivalent of about 33,000 full-time jobs. So a lot of employees, a lot of volunteers, a lot of people help out with nonprofits. They also annually bring in more than $40 billion from the United States. But then you count all the zeros. That is large. And in addition to that, they employ greater percentages of women and people of color in the overall workforce. So very diverse workforces, lots of people. They do a lot of good for the community. And a lot of times people, I find, also get a little tunnel focused on what a nonprofit is. But this right here, it is a lot of them. Houses of worship, universities, preschools, theaters, symphonies, sports programs, senior day centers, health clinics. You know, there's a whole gamut of industries, fields, interests can be, have nonprofits in them. So that's pretty neat. So I figured I would just start off with probably the first bill that's on a lot of people's minds. It's the Stop Terror Financing and Tax Penalties on American Hostages Act. This is a federal bill. It's not a law yet per se. Also known as H.R. 9495. It was passed in the House. It is now sitting in the Senate. It's been sitting there since about December. And essentially, at a high level, it does three things. It postpones certain tax filing deadlines for U.S. nationals unlawfully detained or held hostages abroad. All right, that sounds good. Number two, it allows for a refund and abatement of tax penalties and fines paid by hostages and individuals. Again, a good thing. I feel if I was a hostage, paying my taxes might be lower on my priority scale. Just good to know I might not get taxed for that. But the third piece of this bill is what has a lot of nonprofits talking. And this bill will allow government to terminate the tax-exempt status of terrorist supporting organizations. The concern here is that a nonprofit's activities could subject it to losing its tax-exempt status if certain administrations don't necessarily like where they're investing their time and money. So this what it does more specifically, it will remove tax-exempt status of U.S.-based organizations if they are found to be materially supporting terrorist organizations. The issue with this is nobody really knows what the definitions are in terms of what would be considered materially supporting, or what is a terrorist organization. They have a list of things. There could be the official list of state-sponsored terrorism. There's also some provisions about executive orders and various different administrative suggestions of what would be a terrorist organization. So that's what's causing a lot of question and concern for nonprofits. Who's going to be considered a terrorist organization? What level of support would be considered, material support? And the other issue with it is this will allow the Secretary of the Treasury to designate nonprofits as terrorist organizations. So again, a lot of power with a few people to make these designations. And the issue with that for nonprofits is, of course, you could lose funding, but also it might have a negative impact on your, nonprofit's reputation, your donors' trust in the organization, access to financial institutions. Maybe donors, maybe banks don't want to get involved with nonprofits that might have, be in the press and the spotlight, even if they're never deemed to be supporting terrorist organizations. So a lot of uncertainty in this. As I mentioned, the U.S. Senate, it has it right now. I haven't seen any action to date, but stay tuned. So come to a vote, discussion, all that good stuff. So that's probably the only scary thing I have in my presentation this morning. So let's talk about something else. Let's talk about working with others. So new law in California is the Freelance Worker Protection Act, SB 988. So essentially what this does is it's going to create new rules for having contracts between an organization and freelance workers. A freelance worker is defined as a person or organization composed of no more than one person that is hired or retained as a bona fide independent contractor by a hiring party to provide professional services in exchange for an amount equal to $250 or more, and that can be calculated going back 120 days. So in other words, if your organization is getting services from a single person, or maybe a single person who might be an LLC, an organization, or a corporation, something like that, and you have a very low threshold of money that you pay them for services, you're going to need a written agreement with these individuals going forward.
Can you go back to the...
Sure. Yeah, so these would be, so the reason is the aggregation, just in case of a bunch of small things. Yes, back.
What's the protection?
For protection. Oh, the protect, yeah. So I'll give it for the freelance worker, I'll tell you in a second. Yes, yeah, we got that. So, so for a lot of people, they might not think that they engage with freelance workers, but guess what you do? Here's an example of some of the many industries that have freelance workers. So your marketing person might be a solo person. If you do that, that would be a freelance worker. HR administrators, graphic designers, grant writers. I don't know if nonprofits have grant writers too. Oh, yeah. Fine artists, photographers, videographers, photo, digital content, your translators, writers, editors, content producers, and even specialized performers. All of them are freelance workers. I guarantee many nonprofits probably engage with those individuals. So the agreement has to be in writing, and it has to include the name and mailing address of each party. It has to have an itemized list of the services to be provided. You must state the value of the services, the rate and methods of compensation, indicate when the payments are due, specify how you're going to submit an invoice, the person will, and then you, the nonprofit, have to hold these contracts for 4 years. And now the question in the back, why do we have to do all of this? And the underlying issue you get into is really kind of who's a volunteer versus employee. That's really where your question kind of lies. And California, essentially a volunteer is someone who does something with no expectation of remuneration. Like they have no expectation of getting paid in a benefit, like a monetary benefit for doing whatever their voluntary task is. That's the rule. But kind of your point, I mean, if you give them a gift card for a few bucks does that suddenly make them employees? Are they expecting that? Does that make an expectation for compensation? that's where it becomes that spectrum, you know what I mean? Hard to say, but I don't think it would come down too hard for giving a $5 gift card, but this person's doing a lot of hours of work and you're giving them, significant amount of money, that's
Right.
what matter.
Well, that's the difference, with the young musicians that to do social presentations or whatever. For me, it's like I treat them like an independent contractor.
Yeah, the freelance worker law I mentioned earlier, that might be another thing to
Okay.
look into.
Thank you.
So again, if you social office, that's it. Leaves of absence, always an interesting topic. So we're going to start by the way of top part's background, the bottom part is new. One of my pet peeves is this name, paid family leave. And the reason it's my pet peeve is because everybody thinks it's a type of leave. I'm on, paid family leave. But it's not a leave, it's a wage supplement. That's really what it is. I don't know if they can put wage supplement in the title or how, but paid family leave is actually a wage supplement. And what it does is it provides benefit payments when an employee needs to take time off work to care for a seriously ill family member, a child, support their member in the armed forces who's off to be deployed, things like that. Just help supplement their wage when they take some time off for certain defined parameters. The new piece is down below here. So these paid family law leave claims are now have increased payment amounts. So up to 90% of the wages can be paid out as paid family leave. It's through the state, between the employee and the EDD, through the state. But the state will pay them up to 90% of their wages if they earn less than $63,000 a year, or 70% of their wages if it's over. And then similar, they're going to have disability and the paid family benefits are increasing to about 70 to 90% of the employee's regular weekly wages. And then the bottom one side where there's kind of some crossover. So if the person went on leave in 2024, but they're still being paid in 2025, they'll get the higher percentage rates. So this is just a great state program to help supplement people.
And you said the money comes through the state, so they're applying through state?
Yep.
And then the funds that they're being paid with are the
From the
state
state.
funds?
They're
So
from
it's
the
not, that's not associated with the organization?
No, you don't have to
Like
pay these.
unemployment insurance? or
Right,
anything?
you don't have to pay these amounts. It's a state program EDD. The one thing I would suggest though is if you have an employee that goes out on leave, pregnancy leave, disability leave, baby bonding leave, what have you, there's a pamphlet or brochure about paid family leave benefits. I provide that too.
I've seen
Yep.
that, okay.
Yep. Yes.
Do our disability payments to the state increase to cover this?
Not that I've seen, but good. Yeah, no guarantees, but yeah. But yes, these programs, there's a lot of when you pay out those withholdings and things is where most of this money comes from. Yep. But the reason that we also mention it is AB 2123. So you cannot require the use of accrued vacation before the person goes on paid family leave. So a lot of times what people do is they require that you have to burn up all your vacation or whatever first, then you can go on leave and get these benefits. You can't require that anymore. You can suggest they can voluntarily do that if they want, but you can't force them or require them to do it. So the takeaway here is to maybe just review your employee handbooks and see if you have any language, because sometimes there'll be sentence in there saying, hey, you're required to use vacation before you go on leave or something like that. Just make.
What's the length of the new, are there changes to the length of the leave? Is it 12?
Well, yeah, CFRA and, it's still the same 12 weeks.
12 weeks.
12 weeks, yeah.
Yeah,
Yep.
thank you.
Is it really any different than medical leave? It's all from the disability, the SDI we pay, right?
For which one?
Medical leave.
Yeah, what about it? Or sort of-
I mean, it sounds like it's the same
Yeah.
regulations, nothing
It's similar,
different.
yes. Yeah, you just can't require vacations. Yep. Yeah, a lot of these laws this year they're either just codifying kind of existing things to make it more apparent, or making tweaks that a lot of employers are probably already doing anyway.
What about sick time? Can you require that they use that for sick time? If you have separate vacation and sick time?
Well, if it's paid sick leave under the Healthy Workplace, Healthy Family Act, that's a separate leave bucket. They can just use that. But yeah, you can't necessarily require them to take vacation on that as well. And then this one is, again, it's kind of like the reference about the paid family leave wages. This may not affect you on a day-to-day basis, but it's just good to know. So SB 1090 is Disability and Paid Family Leave Claim Administration. So in other words, the EDD is going to try and be faster at processing these claims, and that's essentially what this law is doing. So the EDD is going to issue disability insurance and paid family leave benefits within 14 days of receipt of a properly completed claim, or as soon as the eligibility begins, whichever is later. In other words, get money to the affected individuals faster. That's what this law is intending to do. And it also permits the employees to initiate a claim for disability insurance or paid family benefits up to 30 days in advance of the anticipated first compensable day. So in other words, if a person anticipates they're going out on leave, they can file the paperwork ahead of time to kind of have it coincide so they can have all their dates lined up, and it minimizes the time that they're without funds. So I did not include all of the employment laws for the new year because there's just so many. I tried to tailor over the nonprofits. There were two major, like a lot of employment attorneys, there's two major laws that were passed this year. Crime victim leave is one of them. We're going to get into it in a minute here. The other one, it addressed something called PAGA. I don't know if you guys are familiar with that. It's the Private Attorney General's Act. It means if some employers get sued, the plaintiff's attorneys will bring a PAGA claim. And so what it is a whole bunch of penalties for all the various wage and hour violations that employees might experience. I could have a whole talk on what that is. I didn't bring it included here, but just know that if you get a PAGA letter or you hear the words PAGA somewhere from somebody, call an attorney right away because the new laws have some great ways to reduce the liability and exposure in those situations. But I'm not going to go into that. I'm going to go to the other big one, crime victims leave. We're going to talk about this for a little while, so settle on in. California has had a crime victims leave law for a while now. So one of the areas where people can go out on leave, if they're a victim of crime, family members are, you can take some time off for it. But California revised it, recast it a little bit, all this kind of stuff. So AB 2499, so it's the expansion of paid sick leave rights for victims of crime and abuse. So as I mentioned, this law's been around before. They moved it. They moved the jury leave, your court witness leaves, and victim leaves over into the California Fair Employment Housing Act under FEHA. So take out the labor codes, put it in this FEHA section. What that does is it changes all of these leaves in the sense that there's different mechanisms to enforce, the violations, how you can get, the aggrieved person can get compensation for it, who's going to be enforcing these, these laws, all that kind of stuff. So it may not sound significant, but it is from an enforcement standpoint. And in addition, the California Civil Rights Department is now responsible for enforcement, the CRD. Previously, it was more like the labor commissioner. When they got around to it. Civil Rights Department is much more proactive in investigating, making sure employers are compliant with different laws. So there's a little more enforcement, or the potential for more enforcement to make sure those leaves are being complied with. What this does is employers are prohibited from discharging or discriminating against employees for taking time off to serve on an inquest jury or a trial jury, to appear in court, pursuant to a subpoena, or to try and attempt to obtain relief as a victim of crime. In other words, an employee comes to you, says, hey, I've got a domestic dispute thing, I get this restraining order, the hearing's on Tuesday or whatever. This existing law and then the new law helps give them time off for that. One of the newer things is you have to maintain the confidentiality of any employer requesting time off and any related documentation submitted by the employee. So keep it confidential. Don't broadcast an email thing. So-and-so is having issues, with, look out kind of thing, don't share the details. You can maybe do it generally, but not yet.
Is this unpaid or paid time off?
It is technically unpaid. However, you'll see that paid sick leave can be used and they can use their vacation time too. So yes and no. So it also expands the definition of victims to include employee or the employee's family member who's a victim of a qualifying act of violence. These are the qualifying acts of violence: domestic violence, sexual assault, stalking, bodily injury, threatened with a firearm, something like that. Threatened with force, stuff like that. Pretty much anything you would think of as violence or a crime like that is going to qualify under this bill. Similarly, your employee can qualify under this law even if no one's arrested, prosecuted, or convicted of committing any crime. So employee comes, and the thing about this law is kind of interesting is, I've not seen a lot of employees taking this time off. I don't know if it's either because thankfully we're in a safe area where this does not come up very much, or what I think a lot of times is employers are pretty sympathetic to their employees. So, I mean, if an employee's like, hey, I got mugged last night and hit my head pretty hard and threw me to the ground, I'm sure most employers are like, go to the hospital, do what you gotta do, you know what I mean? So, so I think it just kind of takes care of itself. But I think by these new laws, the state is trying to raise the awareness that this leave is available if you or family members are the victims of crime. And again, it doesn't be conviction or anything like that, Family member is very broadly defined. I listed it there, but extremely broad. Child's parents, domestic partners, grandchildren, all this. The interesting one, though, they added, not this year, but recently, is designated person. And a designated person is any individual related by blood or whose association with the employee is the equivalent of a family relationship. So, that's kind of a newer thing where, it's like, all right, it's not a spouse, maybe they live with somebody, maybe it's, someone who's really close to the person, so they can designate that person as their designated person when they take these leaves. And the employer can limit the employee to one designated person per 12-month period for leave pursuant to the section. So what that means is, it can't be like, hey, my buddy, his car broken into, I gotta take time off, he's my designated person, and 2 months later, hey, my other buddy, his car got broken, I need to tell him that. You can limit who this designated person is to a 12-month period. This is the fine print, just for reference more than anything else. The employees should give you reasonable advance notice of their intention to take time off, but, there may not always be time to do that, so just be flexible with, that situation. And these are just kind of the reasons where, like, don't have time to tell you beforehand, I do these things, but I can bring in some documentation to show you where I was. So, for example, the police report, maybe a court order, or some other evidence from an attorney. That's why I couldn't tell you on Tuesday that I was out for the day, but here's the police report showing why I was absent. Okay, that's cool. So you just can apply that notice that way. They can also get documentation from a whole host of licensed providers, and of course, it's kind of a catch-all in the other form that would really verify the victims of crime, which, again, it's important to know if you need to, but again, I think most employers are pretty compassionate, understanding about employees who have crime situations. I don't think they're too pedantic about the form of evidence of that. But you can limit the amount of leaves, looking at your question about CFR and all that stuff. This leave time can be limited to 12 weeks, and then there's kind of some carve-outs to narrow that down a little bit more. If an employee's family member is a victim who is not deceased as a result of crime, and the employee is not a victim, then you can limit that leave to 10 days. And you can limit that even further to 5 days if the purpose is just to secure a new residence. Someone's got to move out, someone's got to find a safe place for a while. You can give up to 5 days to help them on that. Employees do not have a right to take leave that exceeds the leave time around under federal FMLA or the CFRA. These run concurrently. So concurrent is kind of a legalese term, but essentially what that means is if the employee is eligible for 12 weeks FMLA or CFRA leave, that 12 weeks will run at the same time as this crime victims thing. But if the employee, if maybe your nonprofit's not big enough for FMLA, or the employee's already used up their CFRA, they'll still get time off under this. So your question about pay right here. California's mandatory paid sick leave law, you oftentimes hear this PSL or paid sick leave. It's technically the Healthy Workplace, Healthy Family Act. That allows the use of paid sick leave for an employee who's a victim or whose family member is a victim of crime. As you know, employees get 5 days paid sick leave. So what this now says is they can use those paid sick leave, paid days in connection with this time off for crime victims. So again, time off is unpaid in general, but they can use their vacation and paid sick leave if they want to. The next piece that is interesting and new is the employers must engage in the interactive process to evaluate potential accommodations for an employee who's a victim of the crime or family members, et cetera, et cetera. So in other words, that means is if an employee comes to you and says, hey, I've got concerns about my safety, you need to begin the interactive process similar to what you would do if someone has a medical condition. You try to see what you can do, what reasonable accommodations will let them perform essential functions of their job. It's not undue hardship. You have to do that similar process for crime victims. So what that means is maybe you need to put a lock, on their door in that work area, or maybe take some extra precautions. Maybe not have a direct phone line to their office for the time being, if someone's making harassing calls to them. Evaluate what accommodations you can maybe do to help with their safety situations. So, and we're still on the same law. Like I said, this is one of the big ones. If nothing else, the takeaway from this is everybody who has an employee handbook, and you all should, probably has a crime victims leave section in it. And if you do, just know you gotta rewrite that whole thing. If you're a larger employer and you have 25 or more employees, then you have to provide an unpaid time off for a whole host of reasons. I won't go into them, but essentially, just think of all of the ways the person might need help because of a criminal situation. So get TROs, restraining orders, medical attention, domestic violence services, things like that, counseling, mental health, doing things to increase safety. The list goes on. But yeah, so essentially, the big takeaway is there's a very broad range of reasons why the person can take this time off, especially for larger employers.
I have a question for you. So this is now state law, correct?
Mm-hmm.
So one of the pieces of advice when we were putting together our employee handbook from our attorneys was that if there's already a law in the books, you're not required to put it in your employee handbook necessarily. Things get updated all the time, especially if there's not a section, because sometimes it's really if you leave it there and you don't update it, you are off. Would it be fair to say that's these laws are already covering the employees at the state level, whether you have it in the employee handbook or not?
It's an interesting question, and it entirely depends on the situation. But yeah, so the reason you have employee handbooks, there's usually 3 reasons. Number 1, certain laws, the employer is required to provide notice to the employees about, and so you want to make sure they're covered. Classic example, equal employment opportunity, don't discriminate against race, religion, et cetera. You have to inform them of that. And this is going to follow, you have to inform them of this one. Then the other laws are, kind of to your point, things that are laws, you don't necessarily need to have a written thing in your handbook about it because it applies. And you can decide whether or not to put those in. The reason you put them in a lot of times is to show compliance. So if you are in litigation or the labor commissioner says, hey, let me see, you say you give this employee compliant meal breaks. Well, how do you prove that, right? So one of the ways to say, hey, look at my handbook, see this section right here, that's our policy, everyone knows it, everybody practices it. So that's the reason why you may put some of those in. And then the third thing that you see in handbooks, which is entirely voluntary, is sometimes employers like to put their just practices or general procedures into a handbook. And you can do that too. But yeah.
The piece that our attorney was mentioning was that if you put things in your employee handbook, you have to have mechanisms to enforce it. So if you are a small organization, in my case, with only one really somebody administrative capacity, it's really hard. The onus is on us to enforce all these things that are in there, and obviously you want to have best practices and not do anything that goes against state law. But they can come back and say, hey, you have it in the handbook, why did you need to enforce it, right?
Yep. Yeah, and that's a double-edged, so it cuts both ways, because that's the same thing even if it wasn't in there. This
Right.
law applies to you.
It's the law.
Yep, and the other thing too is nice about the handbook I find too is it's even a good resource for HR. You know, someone comes to you and is like, hey, I'm pregnant, what do I do next, right? HR can go through the books like, okay, we've got pregnancy disability leave, all right, there's a CFRA leave in there, you know, and it can help them as well on what to provide.
Thank you.
So, to your point, you have to inform your employees these rights in writing now upon hire, annually, time that they request it, and anytime they inform you that they're going to need to go out on leave. So, the CRD is going to be providing that form, and they're supposed to have it out by July 1st, 2025. It's called the Survivors of Violence and Family Members of Victims Right to Leave and Accommodations. So, this is another thing you have to put up on your poster wall. We'll get to that in a minute. Whew, all right. Let's move on to some other stuff. Harassment, discrimination, and retaliation prevention. Hey, there'll be none of that here. That's my takeaway. SB 1137, protection for intersectionality of protected characteristics. This law pretty much just reinforces what has been known in California since the 90s, that, you know, if a person is discriminated against, they can be discriminated against for multiple categories. You know, you don't have to pick one. You know, the person, if they're over 40, it's age. If it's their race, it's their race. You can have discrimination for both of those things, the person's of age and their race, right? So this just kind of reinforces that, but gives a little tweak to it in the sense that it's called intersectionality. And the law is just recognizing that different forms of inequality can operate together, they can exacerbate each other, and then result in amplified forms of prejudice and harm. You know, this is not going to change your operations in any really meaningful way, because don't discriminate, you know, against any group or multiple classes, you know, characteristics. So, you know, but what it does do is it amends the Unruh Civil Rights Act to include this and to clarify that in addition to prohibiting discrimination based on one protected characteristic, it also applies in combination. The Unruh Act is the Civil Rights Act in California. That's the enforcement mechanism for it. So again, it's just kind of moving a lot of this labor law stuff is now getting into the Civil Rights Act, which again is more enforcement options. The next one, and this kind of goes into our employee handbook question, is AB 1815. It's called discrimination, race, hairstyles. That's what they went with for a creative title. But a few years back, there was something passed called the Crown Act. And what it did is it said there could be racial discrimination based on historic hairstyles. You know, hairstyles associated with a particular race. So in the handbooks, what a lot of people did is they would say, you know, we don't discriminate against age, sex, race. They might have a parenthetical saying including, you know, hairstyles that have historically related, you know, with certain groups of people, et cetera, et cetera. If you have that in your handbook now, you have to strike out the term historically. It's a small change, you know. So to your point, you know, maybe you didn't have the Crown Act language in there, then you wouldn't have to fix this per se because it's still covered under race, but it was nice to let employees know that you're not discriminating against that. So if you have language about protected hairstyles, just strike the word historically from it. And then the other thing it did is it added these definitions for race and protected hairstyle into the Unruh Civil Rights Act. So just, again, doubling things up.
Great.
SB 399, ban on religious, political, and anti-union captive audience meetings. This was, I guess I'd probably call this the third biggest law this year. And so essentially what it does is it expands upon existing laws to protect employees' freedoms of association rights and prohibits employers from interfering with, restraining, or coercing employees with respect to self-organization and collective bargaining. In other words, the main impact of this law is if there were union organization efforts at an employer, then the employers would require all the employees to come to a meeting and the employer would give their take on unionization. And so this law says you can no longer require employees to attend those meetings. And And it defined it under the two big things. You can't talk about religious matters, and you can't talk about political matters. So you cannot take adverse action against an employee who declines to participate in these employer-sponsored meetings or even the communications. And so there's a definition for religious matters, definition for political matters. But there are some carve-outs, so, and this might apply to nonprofits depending on your mission. You can still communicate to employees any information they're required by law to have communicated to them, but only to the extent legally required. Necessary information to perform job duties, so you can still have meetings for that, of course. Institutions of higher education can meet and discuss coursework, symposia, things like that. And then, of course, public entity employers can communicate to employees any information related to a policy of the public entity or any law or regulation that they're responsible for administering. So, again, just because there may be some political or religious topics, if it falls into one of these exceptions, it's still okay to do that. But it does not apply to employers requiring employees to undergo training to comply with your legal obligations, religious corporations. So again, you're probably going to fall under some of these exemptions as well. Nonprofit tax-exempt training programs requiring students or instructors to attend classroom instructions, field work, a lot of exceptions to it. But so if you do have a required meeting, just double check to make sure that you're compliant. If it is one of the religious or political matter meetings covered by this law, just know that it can be voluntary, but the employee said, you know what, I'm just going to stay working on my widget machine during this meeting, and if they do that, you still have to pay them for it for that time. And this also creates a private right of action for employees to seek monetary damages, injunctive relief, punitive damages, labor commissioner can come after you, things like that. But a lot of this is now being challenged on constitutional grounds, so much like our first bill, stay tuned what this law is going to go into effect and how it will look. Just about done. So updated posting requirements. Who doesn't like posters? So before COVID, one of my favorite things to do was to sit at a restaurant and the little doors would flap open and you'd see that laminated poster, and it'd say California laws 2010 or something like that. Forever. You're like, what the heck? So, but once COVID, it was kind of a good break. People came back, they updated those posters a bit, so it's not as much fun, but still, make sure you have posters. There's a whole bunch of things that employers are required to notify employees about. Wage orders need to be up there, and organizations like Cal Chamber and stuff like that have this great laminated poster that lists all of that stuff. Go get it, it's worth it.
You need a microscope, though.
Yes, right? Yes, you need a microscope, yes. Yeah, I don't know, I've never seen it in a break room, trying to read all that, but, so that California this year is rolling out with more notices that you have to provide. So AB 1870, there's changes to the workers' compensation notice. This notice has been around, but they're adding a little bit to it, and specifically there's a language here that says that the injured employee may consult a licensed attorney to advise them of their rights under workers' compensation laws, and that in most instances, attorney's fees will be paid from an injured employee's recovery. So that's just one that's going to be on there. That should probably be rolled out here soon. We're just kind of waiting for it, but know that. The other one that is a new one is related to whistleblowing laws. This is AB 2299. So employers must post a notice of employee rights and responsibilities under the specific whistleblower laws. And then you have to post this notice. I was thinking of putting the notice up here, but it's just black and white text. It's not very interesting to look at. But whistleblowing is essentially where your employee comes to you or an agency or something with some issues, some concerns about maybe some legal violations, things like that. It's a very broad definition of what constitutes whistleblowing. And then if that employee were later to experience an adverse employment action, maybe demotion, they're let go, something like that, and they'll say, hey, I was retaliated against for being a whistleblower. I told you about this issue, and then what happened, you fired me a few days later or something like that. So this notice is to inform employees of their rights about bringing issues up and not having to fear retaliation, reprisals in that form. And then this was mentioned briefly in our crime victims section, but I'm just bringing it back here because we're talking about posters. So with the expansion of that crime victims leave, CRD is going to develop this form, survivors of violence and family members of victim rights to leave and accommodations. Expect that, later this year, and you'll have to post that as well. And the requirement to provide that notice will kick in once the CRD posts the form. So that means is we don't know when it's coming out, but at some point it's going to come out, and they have to start complying with it. And again, just get like other posters and your wage statements. So I think that wraps us up pretty close to the time. So here's my legalese. It's just me up here talking. Not much more than that. But yeah, if you have any questions, more than happy to yeah.
Just on the posters, so I don't order the big giant one because there are so many changes throughout the year. So I just check periodically on the list of required postings.
Okay.
Is that a good practice to just, and then I just print them and we have a wall of posters?
Yep.
That people can laugh at or not?
Yep. That's a good practice. Yes, absolutely. I'm still a big fan of the laminated because it's one-stop shop. $20, you're done.
Yeah.
But yeah, that works too. The various labor organizations in California, agencies, they will list the required posters that you have to have and notices and things.
Yeah.
And the other thing to think about those too is, as we mentioned with the crime victims leave, you have to provide that notice when the person requests leave. Other leaves have a similar kind of requirement for that, like pregnancy leave comes to mind offhand. If you have kind of packets in place, it's good to periodically go through and make sure those forms are updated. Sometimes they go forever without being updated, but I know they've updated them recently here, so it's always a good thing to go through.
Okay, thanks.
What else gets said?
I have a couple of questions. One is, I hope everybody knows about the workplace violence prevention plan
Oh, yes.
requirement. That became effective July of last year, where everybody has to have that plan and train your employees annually on that.
Mhm. Yeah, I can talk a little bit about that. Yeah, so, starting, this is a lot that came into effect, took a little while to roll out. It's rolled out. Employers have to provide certain plans to their employees. The one people think of a lot is the injury illness prevention plan, IAPP. This new one is the workplace violence prevention plan. They can be in the IAPP or separate. I kind of like it separate, just so it's easy to say, hey, we've got that plan where it is. This is a very lengthy document requiring employers to go through and assess dangers in their workplace and indicate what they are, how they're going to deal with them. You have to inform the employees where to go if they have a safety concern they want to present, what to do in the event of an emergency. And unlike the IPP, this document is specific to the employer. You have to actually really work and write and draft this unique to your organization. And you have to identify who specifically is going to be responsible for administering the plan. And if you have a workplace violence scenario in your workplace, there's a log that you have to complete for that. And you have to indicate when it happened, where it happened. They've got these categories, there's 4 types they call them, what type of violence occurred, who responded, like what you call the police, when did they come, what did you do as a post-incident investigation, and you have to identify the people involved, but you cannot specifically identify them. So you have to keep it confidential. So you can't give names, social security numbers, addresses, you can't do any of that. But you still have to say it didn't happen. That is a very large document. You have to train all new and existing employees on your workplace violence prevention plan, give them an opportunity to respond to any questions they have, and employees can request these documents on very short notice and for free. So, yes, a big one.
Do volunteers need to be trained on it as well?
I was trained volunteers as well. Yep.
And this is internal workplace violence, not if someone came in from the street and did something in their office.
It's all violence.
It's all
It's all violence. So so when I mentioned the 4 types, that's the 4 types. So, imagine we're here, imagine somebody, there's no connection to this place whatsoever, it comes in here and commits violence. You have to put that on your log. The other violence might be like a contractor. So my plumber example, say the plumber, when he was coming in, committed some workplace violence, and I report that. If it's co-workers amongst themselves, report that. Yeah, so it's very, very broad. And again, one other thing is, what a lot of people are tripping up on is there's an exception to some of this. So like, if someone's working from home, you don't have to go into their home and assess the workplace violence there, right? Yeah. But in addition to that, it said, if the place is not open to the public and has fewer than 10 employees, you did not need to provide a workplace violence plan. As I often say, words have meaning. A lot of people forgot that part about not open to the public and just saw the fewer than 10 employees and said, hey, I have less than 10 employees, it doesn't apply to me. Untrue, that's not true. If the places are not open to the public and fewer than 10, so you have to, that's the exception. So if you have less than 10 employees and your coffee shop, you have 5 people as employees, you need a workplace plan. That exception is more like you have a warehouse, no one ever goes there, it's where you'll have storage or something, you may not have to there.
Yeah, I'm just, you brought up a good point. So the Arts Council is hosting this meeting, and somebody comes in from the outside, or one of their employees of the community foundation brings in violence to one of our employees here. Do we have to fill out one of those forms, incident reports about that, even though it's not our workplace?
I probably would,
Just for
yeah,
safety.
because the location, yeah, it's a different location. I probably might have to. Yep. Double check and see.
Okay.
Yep, so. Yeah, a lot of paperwork that
Yeah.
plans, yep. But yes, from on top of the plans, the other plans is the indoor heat illness plans that came out last year. But yeah, so, yeah, a lot of California laws, but these are the, yeah, anything else?